And with that, I'm going to start with our full paper.
Hello, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Roberto Bornhausen from University of São Paulo, Brazil, where I'm a member of the local organizing committee, and this is the third panel of the day. First, I would like to present our platinum sponsors, Jus Brasil and Albert Einstein Israeli Hospital, our gold sponsors, Logarithm, Legal Code, PG Lawyers, and our silver sponsors, Urbano Vitalino Lawyers, Opsi Bloom Lawyers, and Oasis Open. Now, directly from Germany, I would like to present Mr. Dennis Oemüller with the replay of the paper, Structural Text Segmentation of Legal Documents. Right after his replay, he will be available to answer to audience questions. Thank you very much.
And with that, I'm going to start with our full paper presentation titled Structural Text Segmentation for Legal Documents. So this is an equal contribution work between myself and my colleague Satya Almasian. And we have further collaborators Sebastian Lackner and Michael Gertz, also from the Database Systems Research Group in Heidelberg University. So to start with a brief motivation, what is structural text segmentation and especially given legal documents all about? So what we usually deal with in especially legal domain, we have plenty of unstructured document formats, for example, PDF documents. On the right, you can see one example of an end user's license agreement. And so if we look at this document, we can already see that it provides us with a natural segmentation of the context, right? So we have these paragraphs and then even like the headings with a different numbering provide some overview of how we as a reader should interpret this document. However, this kind of structure usually gets lost when we're dealing with a machine readable format. And even when we try to apply segmentation methods afterwards, usually such a paragraph or a document structure is lost. And why is this important? Well, especially for the segmentations, we have a lot of tasks nowadays, for example, in the workshop at this conference, where you're dealing with paragraph retrieval. So having like structured and thematically similar paragraphs is essential. You also have use cases for mergers and acquisitions, or last but not least, document search in general for just cases at like courts, meaning that once we can make sure that a segmentation of a document is still improved in a machine readable format, we're going to have a much better downstream performance, hopefully. And to illustrate this even more is even if we have some completely nonsensical text, like a lorem ipsum example here, we're still going to interpret this as a semantically coherent unit, which is very important for our actual work here, because what we're now doing, and specifically comparing to previous work, is instead of focusing on a segmentation that bases itself just on a sentence level, this has some major problems. Specifically, there is a very narrow context given just by using a single sentence as a boundary. And the other question is, if we already have these thematical units like a paragraph, is it even useful if we split at a lower level, meaning the sentence level, than the paragraph level? And when we look first into this, specifically for the legal domain, there is a lot of hurdles that come with using existing methods. If you're looking at learning-based approaches, they usually come with custom architectures, which have like restrictive transfer learning capabilities. Most of them are some kind of hierarchical LSTM model, which is very difficult and unstable to train. You have exploding and vanishing gradients. And last but not least, they usually require large amounts of training data, which is not available in domain-specific applications such as the legal domain. And I think actually one of the major limitations that we encountered was not just using tools, but finding some of them. So they are really hard to come by. They either have no documentation at all, they are outdated. We had like one of the repositories that we tried to use that had only 20-year-old C code, no updated version was existing out there. And that was the most common scenario, actually, we weren't able to find any code at all. So even if I wanted to apply this to a legal document, I would not have any working solution at the moment. And so this is where our work comes in with its core ideas. And so we have these three main areas that we're going to focus on. So the first one is relatively trivial in understanding what is happening here. We're simply moving the attention span of our segmentation model from a sentence level to a paragraph level. This gives us a much more natural transfer of what elements are existing in the text already. and they kind of serve as a natural boundary that we assume in our work. Similarly, this also introduces a much broader context window, which can be helpful for methods that rely on this contextual embedding. And last but not least, paragraph structures are also something that we can semi-automatically extract from documents that have some vague annotations, such as XML or HTML. The second step is actually more on the model for the segmentation itself, where we rephrase it from a purely sequential document segmentation, where you have one input sample of an entire document, to a pair of binary classifications, meaning we simply look at two subsequent paragraphs and predict whether those are actually thematically coherent. This makes it much more easy to train. This is more stable and has less problems of an architectural sharing. And it is comparatively cheap in that we can use pre-trained checkpoints to actually use existing models and retrain them to our purposes. Given that we now have a different model formulation, we also rely on a different sample generation. And we actually present two different strategies in this work that make it very efficient to sample from a small number of documents even, and that can generate many more samples than the number of documents that are available. We're going to talk about this in more detail, but first I want to just again reiterate from a theoretical point of view what exactly we mean by structural text segmentation. And so what we assume here as an input is usually some kind of document that has a natural structure in terms of the paragraphs here. And indicated here with the colors, we have first 3 paragraphs that are topically coherent, and then a 4th paragraph that is covering an entirely different topic. And now basically the task of structural text segmentation is to generate this labeling in the terms of colors that we do not have a priori. Again, what I already mentioned is that traditionally you would feed the entire document as one single sample and generate one single prediction for this entire document. This is already where we have the mentioned problems of long-range dependencies. So the question becomes, is it even relevant for the 4th paragraph what happened in the 1st paragraph? And to exemplify this, in reality, you will have documents that are spanning several pages. And here really the context loses its meaning beyond just the immediate neighbors. Another downside again mentioned was the hierarchical training setup. To deal with the embeddings of single paragraphs and then predict over those paragraph embeddings again, you require usually very convoluted architectures that were used in related work that we try to abstract away here. So this is our rephrasing of the segmentation as a binary prediction problem called same topic prediction. And essentially, we make some form of Markovian assumption. So instead of relying on the entire context for the document, we just say, okay, we are training a classifier to predict whether 2 adjacent paragraphs are belonging to the same topic. Given our same sample document shown on the previous slide, what now happens is instead of a single forward pass, we're going to do at inference time 3 different predictions where we ask whether the first 2 paragraphs would be of the same topic, where the 2nd and 3rd paragraph are the same, and consequently the 3rd and 4th paragraph are of different topics. So this immediately removes the overhead of the sequential nature that I've previously mentioned. And the other point is, if we look at how those samples are basically laid out, just having the neighboring samples, it becomes relatively trivial to just sample many more pairs of paragraphs from the same document. Again, just to highlight, we can still apply this to the entire document sequentially when we're doing inference later on. Okay, so now to the actual methods used in this work. I'm sure you've heard plenty about transformers this week already. I just wanted to mention why we use this specific architecture here. And there's a few points that we thought made sense from our standpoint. Firstly, those come as large and pre-trained architectures, meaning that we do not have to worry about long and expensive training ahead of time. And especially since we can continue from those pre-trained checkpoints, it is much easier to achieve state-of-the-art results. For the fine-tuning as a binary classification task, the architecture basically looks like this, that we feed in 2 separate paragraphs as a single sample, separated by a special token, and will retrieve a class label that is then the prediction of whether those belong to the same paragraph or not. A small implementation detail here, we're actually using Roberta because they have slightly improved performance on all tasks, but we have experimented with BERT as well in this work. Our second methodology is the so-called sentence transformers, which was introduced by Ramis and Gurovic. Specifically, this is a variant of the transformers which uses this bi-encoder layout. And if you again look to the figure, what happens instead is that we're feeding only one paragraph in a forward pass, and then retrieve these embeddings U and V, and basically predict based on the comparison of those two embedding vectors U and V. The main advantage is that SentenceBird performs extremely well on embeddings and similarity tasks, which is shown in the original paper. And the more important aspect for our work here is that it also effectively doubles the input length. Because remember that for the BERT model, we can only feed 2 paragraphs in one pass. Getting back to the actual sampling of our training instances, we have 2 main strategies here. The first one is called random paragraph. And what we always do is essentially we sample from a reference pair, here denoted in purple, both a positive and negative sample. In the instance of random paragraph sampling, what we do for the positive sample is, or for both actually, we just aggregate all of the red paragraphs into one class and sample a random positive pair from this same topic, meaning that this can also come from another completely different document that has the same topic in it. The negative pair, similarly, will sample from all of the paragraphs across all documents, but from a different topic. And that the problem of this method is that it requires some cross-document normalization, where we basically have to actually normalize here and verify that these sections are actually the same across different documents. The improved strategy that we use is the so-called consecutive paragraph sampling. The name is slightly misleading, but essentially what we do is we restrict ourselves by just sampling from the same document 1 in this instance, where both positive and negative pairs have to come from within the same document, but however, still from either the same section or a different section. The main advantage is, again, that we now no longer require any cross-document normalization, which makes the annotation process for our initial training setup much, much easier. However, there is this one remaining question that we also want to answer in the experiments, that is whether it generalizes well to unseen topics, because now we do not have any relevance between the documents, which might lead to a much poorer generalization. Talking about the data set that we used in this experiment, we actually obtained a new terms of service data set from website terms of services. So the main point being that terms of services always have to be available from the landing pages directly, making them relatively easy to extract. And the other benefit is that while they focus on a legal context, they have relatively similar structures and topics across many different documents. So we will obtain, for example, shown on the right, around 20,000 of the documents that have a limitation of liability clause in there. And similarly, we normalize all the other sections as well. This is only an excerpt of the most frequently appearing one. But there is many more because we extracted overall around 40,000 documents based on this Alexa top 1 million list of English websites, from which we then automatically extracted the hierarchical information that was available in their terms of services, which includes linking different paragraphs to a specific section. The one manual annotation that we had to do for our random paragraph sampling is the mentioned cross-document normalization. Specifically, limitation of liability usually was spelled in 3 or 4 different ways. You had limitations of liability or liability just as a single word, referring to similar topics that were manually grouped together. And after all the pre-processing, we're left with around 40,000 usable documents, depending on which task specifically we're looking at. The average length being around 22 to 23 paragraphs and around 3 sections. Now actually moving on to the experiments. So the evaluation that we did was firstly verifying that our binary classification actually works well, and then transferring this into an actual downstream segmentation task. The setup that you're seeing here are the basic methods that we compare for both the classification and segmentation. We will introduce further related work in the actual segmentation task. But for now, baselines that we used are simply averaging glove embeddings. In the previous presentation by Malte, we've seen that this usually leads to really good performance out of the box. Similarly, bag of words and TF-IDF vectors are a good approximation and turn out to be actually competitive with related work. But what we specifically are interested in is fine-tuning transformer models, where we choose a Roberta base model with a classification head, so the so-called ROCLS model, and then a sentence transformer variant of the same Roberta-based model called STRO. As a brief side note to the hyperparameters, we usually sample 3 positive and negative pairs from this per paragraph in the document. And we run all models from 5 different random seeds to account for any statistical variance in the training procedures. Training is performed over 2 epochs for the transform models, and generally our 80-10-10 split is consistent for training, development, and testing. Now, looking actually at the same topic prediction task performance, we compare both the different models and the different sampling strategies. One slight caveat to this is because we sample differently both for the validation and test sets, we cannot compare models between random paragraph and consecutive paragraph sampling here. However, we will still be able to compare those on the next slide when it comes to downstream performance. What we will look instead is how these models perform across like the board, meaning basically we can still look at how glove averaging performs in comparison to the, for example, sentence transformer models. And we see that the sentence transformer models for both strategies perform extremely well, much better than any baseline, and specifically show a better performance, although only slightly better for consecutive paragraph sampling compared to the standard transformer models. Generally, what I want to highlight is also that random paragraph sampling seems to have some inconsistencies in the training stability, which can be due to a variety of reasons. However, we noted a large variance in the performance that was actually subpar to some of the baseline methods. Yeah, going on to the actual segmentation and then circling back to the tasks that we actually wanted to solve here. We have this traditional segmentation metric called the boundary error rate PK, which is frequently used in other segmentation works. It gives essentially a probability of 2 samples being incorrectly labeled when compared across the document. And this means the lower the error rate, the better the method is. Furthermore, we introduced 2 related works for which we could find working solutions. One of them is GraphSeg, an unsupervised method introduced by Glavash et al. That is usually also working on sentences. And similarly, Wikiseg, Koshorek et al.'s supervised segmentation model that was trained originally on Wikipedia data, for which we do a training from scratch to have no advantageous embeddings. What we can still see here, and which is consistent with our expectations, is that the consecutive paragraph sampling for every method performs significantly better than the random paragraph sampling. So specifically for the transformer-based method with this classification head, we see that the consecutive paragraph sampling is indeed more stable on the downstream performance as well, and almost competitive with the sentence transformer model from the both from the random paragraph sampling and consecutive paragraph sampling. Similarly, all of the transformer models, with the exception of the unstable Roberta CLS model, outperform the baselines as well as the related work. We do denote that while it seems that those results are extremely bad, this might be mainly due to the fact that they were originally designed to work with sentence inputs and not paragraphs, which is especially detrimental for the unsupervised method GraphSeg. However, for Wikiseg, we assume that there was also some implementation detail that we might have gotten wrong, leading us to the conclusion that those models would not have been usable by somebody trying to get segmentation on legal documents. Because we personally found this method to be rather hard to understand, what we also did is come up with an alternative evaluation metric for the segmentation, specifically on paragraphs, which is the so-called accuracy up to K. It's rather simple to explain. Essentially, we account for the fraction of documents that have less than or K mistakes. So this actually gives some relevance to our error rate seen on the previous page, because even though we tend to have rather low PK values, if we tend to look at the transformer models, which is this upper curve, even those have only around a quarter of the documents that were classified entirely correctly. Keep in mind, again, those are around 23 predictions that we have to do per document. However, if we account for only 2 mistakes, we can see that already 2/3 of the documents are classified correctly, which might make this still an acceptable segmentation for many downstream applications. But more importantly, it allows us also to give a generally more interpretable result, because even here we can see that the best performing baseline method, the average glove with consecutive paragraph training, is still significantly worse than the transformer models that we see here, with the one exception, again, being the very unstable Roberta CLS random paragraph sampling model that performs even worse than that. Just as a reference, before anyone would ask the question, we also just tried predicting what would happen if we just said, okay, all paragraphs belong to the same topic, which is the last red curve here, which is predicting simply just always the same topic. Yeah, and with that, we're coming to a conclusion of this presentation. So in summary, the main points that we introduced in this work is a simple but effective training strategy for document segmentation, specifically on paragraphs. We supply a new resource available to the community of web terms of service documents, and have shown in experiments that our proposed transformer binary classification models also translate extremely well to downstream performance tasks. As a brief outlook, what we can do in future work is essentially investigating the actual retrieval performance, specifically in long legal documents. So I've already mentioned in the introduction some of the use cases that might be applicable here. We're also working right now on a more general text segmentation model, which is trained on Wikipedia data, just to see how that compares, maybe also in a zero-shot setting with domain-specific data. And largely, we've already heard about other transformer models that have a longer input context, which might be beneficial for our training on paragraphs. So this is one of the options that we can pursue here as well. With that, here is a link to both our code and data, and as promised, you can easily use this model through the Hugging Face library. Feel free to check it out and give us feedback on our work. And with that, I thank you for your attention, and I'm happy to answer any questions that you have.
Thank you very much, Mr. Dennis. And now we have a question from the audience. Aline Macoin from Federal University of Paraná says, very interesting work on the automatic inference of topics in texts. Do you think as a future work to identify if the text, besides having the same topics, can treat the subjects in the same way? This would be very interesting for analyzing court decisions.
Thanks so much for the question. So actually, there's 2 points that I want to address with this. The first one being that our main focus was less on the actual establishing of a novel task specifically for this inference. And so we mainly treat this segmentation as a pure pre-processing step to existing downstream applications. However, given that this question does actually bring up some nice points, there is 2 works that I can think of that kind of go in a similar direction. The first one actually takes this segmentation step a bit further and does automatically infer the topics or the topic headings, which they do on Wikipedia data. However, I think this can be relatively easily transferred to the legal domain as well. The work I'm referring to is called outline. The task is called outline generation in this case. I believe it's a paper from 2019. And the other task is what you're referring to as subjects. And I hope I interpret this correctly. Would be dealing with, I think, too narrow of a context. The problem here is that our main advantage is that we can automatically extract large amounts of data without any major labeling. However, if you do have such larger corpora, I think the closest that you could get is something like the EURLEX corpus from the European Union, which does provide you with, I think, about 50,000 documents, which might have enough samples overall to allow for a classification in that sense. However, in my opinion, the context with our paragraph-based method would be probably too big, and you would have to revert back to traditional segmentation methods that only treat an individual sentence, because only in that context, I believe that a subject is unique enough to perform some actual classification. How good the performance would be, I don't want to comment on. It largely depends on how many different labels you're going to have as a target value space.
Perfect. Thank you very much, Mr. Dennis, for your participation again and your brilliant work. And now, following the next presentation of the day. But first, of course, I'm so sorry. I would like to give you the stage again for last words. If you want to say thank you to anyone or
yeah,
anyone.
Thanks so much. I appreciate the questions. So really looking forward to having more discussions. If you want to catch up on this work specifically, I'll also be in Gathertown afterwards, after the session. And then I think I will get back to give more space for the short paper presentations afterwards. Thanks.
Perfect. So yeah, we meet there at Gathertown. we invite everyone to join you as well. Thank you very much, Mr. Dennis, for your time and your space. And now, following the next presentation of the day, we have 2 live presentations next. So the next one also from Germany, Mr. Ingo Glaser and Mr. Ton Chenbagge are here with us. They are presenting a short paper called Anonymization of German Legal Court Rulings. Please, Mr. Ingo Glaser, welcome to the stage.
Yeah, thank you very much for the invitation. My name is Ingo Glaser, and it's my pleasure to introduce to you a work I've been working on most recently with Tom Schamberger and Professor Dr. Florian Mattes, entitled Anonymization of German Legal Court Rulings. And so today, the outline, what I will do with you is I start with a brief motivation about the topic. Why are we doing that? What are we exactly doing? Then I go into the approach we have utilized. And then I talk a bit about the data set we've used, because the data was a bit tricky in this scenario. And then I talk about the results, which will then also conclude my presentation. So the motivation. You can see here on the left-hand side an excerpt of an anonymized court ruling. I know this is German, but for now it doesn't really matter. And of course, court decisions, they do contain sensible private information. And anonymization as such is a quite heavily researched topic. And particularly for the court rulings, it's quite crucial. So we actually interviewed German courts to get an idea about the publication and anonymization process. As we only have 10 minutes today, we will skip the details of the interviews. However, it turned out that the whole publication pipeline of court rulings is quite expensive, and that this tedious and manual process actually leads to infrequent publication of legal texts. And this has 2 downsides. First of all, if you're a lawyer and you're doing legal research, not every verdict is available, and also the data is spread through different publishers. And then also the second part is, which is more here in the law and I community, that of course we don't have much available training data. And therefore it would be good if we can support an anonymization process to overcome these 2 issues. And therefore our solution is to develop an automated or semi-automated anonymization process. And however, the challenge is that as of now, we do not have original non-anonymized data sets. We only have anonymized data. And then we were thinking of, okay, how could we utilize this non-anonymized data to come up with a nice solution? And this already leads me to the approach. We thought about a context-based approach. Again, this is German, but it basically says the offers on the homepage of the plaintiff, ... with ... there was previously some sensitive information like Bauer or Müller, is based on the concept of a product detail page. And our idea, we have basically 2 main assumptions. First of all, we assume, and we figured that out during the interviews, that there are specific patterns of placeholders used in court rulings. So we can detect these placeholders to know where a sensitive information was originally. And then second, that the sensitivity of a token actually depends only on the context, or at least it can be purely detected based on the context and not on the token itself. So therefore, we came up with this solution. What did we train or apply in detail? Basically, we utilized BERT for this one because, as you know, we detect the placeholders like ... And then, of course, it's high risk that the model will actually just learn that if there's ... it's an anonym token, which won't help. So therefore, we use basically the masked language model capability of BERT and masked these tokens along with random tokens. And then we just put it into BERT. We take out the final hidden state as embeddings for each token. And then on top, we put different bidirectional LSTMs. I think we trained a couple of different variants, and we reported in the paper the best 3 variants. Usually, I think it has been either 4 or 5 layers. And then at the end, we do so we see this as a binary classification task, whether a token is then sensitive or not. And before I talk about the results, I go to a data set. We collected data from the district court in Munich and from the ordinary jurisdiction. It was around 1,200 documents. It's not really much, but for this kind of proof of concept to see whether our general idea to utilize anonymized data to train something like that is working. We took this data set, and for the evaluation part, actually, we decided to take two data sets. So first, we manually rewritten a small excerpt of the data set to replace it with original information, and then we played that back to the court to ensure that it's actually somehow similar to a non-anonymized document. And then also from the Munich Financial Court, we got some original and anonymized documents for the evaluation purposes. And we wanted to take two different domains because we have the assumption also in the interviews that actually different courts and different court types, they do differentiate between entities which need to be anonymized. And therefore, we want to see whether we actually can apply a model trained on ordinary jurisdiction, like on a financial jurisdiction, or whether we actually would need to train different models. Okay, before I go to the actual results now, I briefly show you a demo of a prototype. Due to time reasons, I have this pre-recorded so that nothing can go wrong. Because for us, it was important to integrate this also already in the web application, which can be used at courts to also gather feedback. And therefore, I will just play the video for 2 minutes.
Change the results a bit, and then you can download the final document. So let's do that quickly. You choose a document. I have here the verdict. And just as a remark, this is only the tenor of the verdict, but that doesn't really matter. You can also here show structural information which won't be processed by our algorithms in the background. We can then go to the next step, and now our trained models will process the document. We have also here some help, but skip that for time reasons. And on the left-hand side, you see now the document, including annotations of sensitive information. On the right-hand side, we also have an overview. And as you can see, the model really pays attention to the actual entity. It's not just a simple named entity recognition. So you can see here, the location Munich won't be anonymized. However, this true bearing will be. And also, like the plaintiff, if a buyer, for instance, is detected, then that should be anonymized. We can also see here a small issue. So the model detected the word Flurstück as a sensitive information, which is wrong. So we can remove that and add the actual number, which should be anonymized. And then on the right-hand side, as I said, there's a tabular overview, and we can also choose here some replacements. So we can say we want to have replaced the word buyer with B dot, Eva with E dot, and let's say true bearing with a few stars. Now, if we press continue, we get actually our anonymized court ruling. We can also download this, and then you can see that we actually have our structured information back. So this is now the anonymized verdict, which could be now handed to the outside. You can see here the plaintiff is replaced, true bearing has been replaced, and Flurstück, for instance, as well. So yeah, thank you very much. Okay,
so that has been a demo. So now you got an idea how the tool actually looks and works like. And as I said, for us it was important also, this is now highlighted by the results of the evaluation, that this is not a fully automated process as of now, but it should be a support for the court employees. And therefore, first of all, we had to evaluate the placeholder detection, because that's of course crucial. And we got their precision and recall above 95%, which is quite good. But of course, you need to keep in mind that this is then also some kind of upper limit for the whole process. In terms of model variants, the concrete variants are denoted in the paper. But as you can see, the models perform actually better on the Munich District Court dataset than on the Munich Financial Court dataset. So this suggests again that we would need to train models for different court types. And for us also, it was more important to have a higher recall than precision, because if you mark too much insensitive information as sensitive, that's a lot of work for the lawyer. But they can easily remove the information because it's just obvious and they just need to click on it. But the recall should be high because it's of course important that they don't miss sensitive information. However, when we looked at our results, we figured that there is one kind of crucial issue, And this is that in most cases, the model can distinguish sensitive passages from insensitive ones. However, often, here's an example, for instance, this is basically a defendant, and this is a customer, and this is again the defendant, and this is the concrete customer name. And if you just look at the context, then actually sometimes the model detects the reference to the customer, which is the word customer, also as a sensitive information. And this, of course, should not be the case. So basically, our initial assumption that it only depends on the context is just partially true. And therefore, in the future or for future work, we have two possible solutions. One is to use a general purpose named entity recognition beforehand, because then the model will only detect, basically, it's just a binary classification after named entity recognition to say it's sensitive or not. Or on the other side, we could also utilize non-anonymized court rulings. And for that, we are currently developing a prototype which would run at the court, where basically the court can internally enter original verdict and an anonymized version. And then we can basically do a diff and create a kind of pseudonymized verdict out of that one. And we could use that then internally for training, because then there's no confidential information anymore. So yeah, that's it from my side. Thank you very much for your attention, and I will be happy to respond now to questions.
Thank you very much, Mr. Glaser. Such an amazing work. I'm very happy to be here with you, since my research is based on the same topic. And we have a question here. Do you believe that the results you obtain would have a reduction in the percentage of correct answers if they were trained and tested only with decisions without any anonymization?
That's a good question. I hope I got it right. So I just need to recap it. Do you believe that the results you obtained would have a reduction in the percentage of correct answers if they were trained and tested only with decisions without any anonymization? I mean, yes, of course, there would have been for sure a reduction, because I mean, then the model basically, I mean, you need to see it like this. If we would have documents without any anonymization, we would actually need pairs, you know, one is anonymized and one not, and then we can use that for training. Then we would actually increase our performance. That's at least the assumption, and we are quite sure about that. However, if it's data without, if there's a bigger portion of data without anonymized entities because it's maybe not required, then of course the model will learn less and also perform worse. So I hope that responded quite well. Otherwise, feel free to contact me later, either via email, or we can look around in GatherTown. Then we can discuss this, or also maybe other questions in more detail. Also for you, Roberto, as I said, that it's very interesting to you.
Perfect. Thank you, Mr. Glaser. Amazing job. And now following the next presentation, a short paper straight from Malta. I would like to call to stage Mr. Joshua Elul. Please, Mr. Joshua, the stage is yours.
Thank you, Roberto. So I'll just share my screen. Okay, so this is work that we're presenting from the Malta Digital Innovation Authority, a national technology regulator that was set up in 2018. And we're just going to give our perspective in some work that we've done in providing some sort of form of regulation on artificial intelligence. And this is work from not only the staff of the Innovation Authority, but many consultants who we've reached out to. So indeed, there's a spectrum of opinions when it comes to what is required to regulate AI, and should we even regulate AI, from complete mandatory regulatory compliance to freedom and allowing for the market to self-regulate itself. However, let's take a step back. Let's first start to consider that AI is first and foremost software. And we've been writing software for decades, from all sorts of different types of user interfaces to embedded software to robots. And we all know that software works. We've been doing this for decades, but indeed it doesn't. Indeed, even the simplest of software ends up with numerous bugs. And we can even see real live robots crashing due to bugs crashing. But if we look back towards history, some infamous bugs that we can think about are the NASA Spirit rover that became unresponsive after a few weeks that it landed on Mars. And this was due to a bug in its deletion software routine. The Theorem-25 radiation therapy, which was responsible for killing at least 5 patients that are known. And this was due to a user interface bug that resulted in the nurses using the actual machine were displayed with one value, but the radiation therapy value actually administered was another value inside of the software memory. And these bugs are on relatively trivial software. And nowadays, we're using artificial intelligence, which is much more complex. And it's not just about ensuring that the software itself is correctly, but also the training and the data that these algorithms are trained on, that they're suitable and sufficient for the particular problem. So we're not only dealing with correctness of software, we're also dealing with adequate procedures for training. And which safety critical AI-based system will become infamous and added to this list? Well, ideally none. So what we considered was, let's start by focusing on raising the levels of technology assurances in certain types of systems when we're using artificial intelligence. Now, I could go through this story discussing how AI from robots will lead to robots not taking any more orders from its humans and eventually putting us into some sort of matrix, right? The whole concept of the simulation theory, AGI, so on and so forth. There are many out there, especially in the academic community, certain sides of it will say that AGI will never exist. Nonetheless, though, many policymakers, many individuals out there are still scared of this end of the world scenario that AGI will take over the world. So irrespective of whether we agree or disagree that AGI will ever exist, we took the stance that some safeguards are definitely needed for AI. And AGI is not upon us right now, so we will start by regulating and ensuring certain principles in ANI and leave AGI for future. So the first policy decision that we made was differentiate between ANI and AGI and start by focusing on ANI. The next question that came to us is, should we regulate all artificial neural intelligence? And indeed, there are certain use cases where some form of regulation, some form of assurance needs to be applied, such as if we're looking at court decisions where an individual's life could be on the lines, we need to make sure that we're regulating that in a sound manner. Similarly, if someone is going to apply for a bank loan, and we need to make sure that there's no unjust bias in that procedure. We shouldn't have an individual behind a bank making a decision, whether it's software or not, making decisions based upon perhaps the brand of clothes that someone's wearing, because they may be able to look at statistics and find that this particular type of client would end up eventually defaulting. But at the same time, there are many types of systems that likely do not require regulation, even if using AI. So if we think about music recommendation systems to some extent, the more bias that is in my particular recommendation system, probably the better. I want to hear music that I like. And if I'm put into that category, that will probably provide better recommendations for me. Now, obviously, there's difference of opinions on that. And in regards to if someone wants to hear within their particular category or preferred categories or not. So the second policy decision that we looked into was do not regulate AI across the board, because there are many applications which would be stifled if we regulate them. Only regulate where required. So we looked at non-AI software-based software as well. Let's say a bank processing algorithm ultimately makes a decision, approve the loan or do not approve the loan. And whether this is based upon statistical, rule-based systems, random, whether it's even based upon a human. At the end of the day, it is this decision that is critical. And we don't want to leave any loopholes. Whether we're using AI or not using AI, this decision-based system needs to follow whatever principles that we want to instill within a bank loan processing system. And again, like I said, whether it is software or whether it is humans, it is the decision and the principles that we want to look at. Now, if we create AI regulation and it captures non-artificial intelligence software-based decisions into it, we're regulating more than just AI. We are regulating software. And could we stifle software by regulating all software? So we need to be careful by not over-regulating or specifically regulating AI that will capture non-AI software inside it. So the question that arises, should we regulate all software? And whether it's software or whether it's a human behind the decision-making process, what we need to actually focus on from our perspective, from starting off with initial policies, is that we want to make sure that this decision is not discriminating, irrespective of whether it's a human or whether it's software. So we want to focus on the sector, not on the software itself. And if you look at many sectors like bank loans, discrimination, court decisions, a lot of GDPR, a lot of regulation already exists and tells us what we need to do, even in terms of bias and discrimination. So by creating regulations specifically for these types of sectors, are we now going to be replicating law? Are we going to be replicating certain laws that define you cannot discriminate? Because these laws already exist. So the third policy decision was do not mandate artificial narrow intelligence regulation, rather focus on regulating the sector and activity, not the technology. The technology then needs to abide by whatever regulation is applied to the sector. So we then went ahead and said, okay, we'll regulate the sector. Now we're often using AI-based systems and other types of systems in such sectors. And we could end up seeing bugs where individuals are cheated of giving certain loans or are subject to unjust bias due to perhaps software bugs. So what we started with is by looking at assuring that the software that is used in these types of regulated sectors and instances and safety critical systems, we need to make sure that this software is fit for purpose. So the fourth policy decision that we looked at was for regulated and safety critical sectors and activities, technology audits need to be considered, especially if they're AI, artificial narrow intelligence-based systems. Now, the issue with technology audits is you'll find all types of different auditors out there, those who do a great job, high quality, and they may be quite onerous in terms of costs, and those who do perhaps not such a good job and are not so thorough, and they'll be cheaper. And as a national regulator, wanting to assure that these sector-based software implementations are fit for purpose, we need to assure some level of assurance in regards to the levels and qualities. And how can we do this? Well, we need to look towards some standards. And the fifth policy decision was, in order to assure these levels of standards and audits undertaken, a national technology regulator was set up. And that is what the Malta Digital Innovation Authority became, which is the authority responsible for the levels of assurances, audits, standards, which are undertaken. So the first steps in regulating when we created this framework was to create a voluntary regulatory framework, where if you wanted to undertake certification and have your system audited, you could. But then when it comes to regulated sectors and other safety critical systems, such as, let's say, fintech applications that is regulated by the financial authority, the financial authority itself could mandate such technology audits, or other laws could mandate such technology audits. So we're primarily a voluntary regulatory regime, but we can be mandated through other regulators and laws. And the Malta Digital Innovation Authority was set up to ensure these levels of standards, and the laws were enacted. Now, the framework defines an innovative technology arrangement, which is not specifically on AI, it's wider. And the reason is because we have very similar issues in blockchain, DLT, and other software. So we started with a wider definition of what we want to include, and then we created specific standards when using types of technology. And currently within the ITA, within the ITA framework, we support artificial intelligence systems, architectures, code, and related software. So it's quite a wide definition. And just an overview of the process, when we're undertaking an audit, or actually the whole regulatory framework, the MDIA, what it does is it vets and scrutinizes system auditors. These are external companies who have the expertise, who can undertake such audits, because we can't do that in-house. Otherwise, we'd be struggling to find the right resources. So this is one way of outsourcing our regulatory arm to existing audit companies. And the different audit companies have their own subject matter experts, and we also verify them that they have the right levels of experience and education and know-how to undertake whatever audits they claim that they can undertake. So we heavily scrutinize and vet them, and they're approved. Then when someone wants to come and audit their system, there needs to be a known identifiable party who's running the system, and there needs to be a technology administrator appointed who can intervene in the system if required. For example, if the system has gone haywire and for some reason it's causing damage, the technical administrator must have powers of intervention to intervene if required. And we vet the individuals as well. Besides this, there must be a forensic node. And a forensic node is responsible for collecting all information to do with the running of that system. Now, the Innovation Authority releases guidelines that the auditor, that the subject matter experts must abide by when they're undertaking these audits. And we've released guidelines specifically for artificial intelligence, and which define the different control objectives that they must check. The system auditor then is the actual one responsible for undertaking the audit, because they're the ones with the expertise. And they might find that the whole system is seen to be sound, and they issue an audit report. That audit report at the end of the day is passed on to the Innovation Authority along with the applicant's application and a description of what their software, what their AI is doing. And the authority then undertakes scrutiny on the report and on the application to make sure that the audit report seems sound and the process is undertaken to reach the conclusion that levels of technology assurances applied are adequate. And if this all goes well, then we issue certification and the software is deemed to be fit for purpose. So looking at the process, the applicant really comes to us with a blueprint of their software and the application. And like I said, that goes to the system auditors. Then along with the system auditor reports, if the MBIA is happy, we finally issue certification for that. Now, how does this structure help? We're giving applicant due diligence, so there's a known identifiable party behind the system who can be held liable if required. There's technology due diligence being done by the system auditor, reaching a level of assurance that the system is implementing what it says on the box. Like I said, there's the identifiable known party, and there's a forensic node, which can be used for post-mortem events if required, if something went wrong, or if we want to, if we're not sure why a particular algorithm took a particular decision, this can be investigated with the authorities or even other authorities. There's some power of intervention for when things do fail, and there's some first point of contact who can act when things do fail. And that will be the technology administrator. Now, in a court of law, according to our laws, it is the English description that will prevail over the implementation if there's any argumentation between the various parties involved. So that provides at least some sort of assurance in regards to what the system is expected to do. Now, that's what we started with. We started with quite an onerous audit framework, and this is not appropriate for all types of startups, of companies in various phases, because it's quite expensive. So we then further looked into creating a technology assurance sandbox, which we've just launched. And this is allowed for more flexibility in regards to the types of assurance that are required, and allows for us to scale down the framework to be proportionate to the risk involved in the particular operation. And in future, we're looking into other tools to include into our regulatory framework that might even be able for us to allow for lower levels of assurances for lower level risks. And these two tools that we have really now, we feel that they're going to help us to adapt quickly to other regulatory regimes as they're put forward, such as those from the European Union, for example. And this is just one part of the puzzle. This is just technology assurances. This is what we started with. And indeed, we need to look forward to defining liability, issues of protection and privacy, specific solutions for specific sectors, ethical considerations. This is just one piece of the puzzle, and this is where we started, and we're looking forward to see how this regulatory framework may fit into the future of regulating AI. So that's it for my talk. Thank you.
Thank you very much, Mr. Joshua Eller, for your presentation. And now we have a question from the audience. We actually have two questions. Mr. Dennis is here with us. Mr. Dennis, can you confirm that the question was made by you?
Yeah, that is actually my question, yes.
Okay, would you like to make it? Please be free.
Okay, yeah. So the question is specifically, we've seen as a consequence from GDPR that specific services are just no longer available in Europe because they would have to follow specific regulations. Did you investigate how you can ensure that having new regulations doesn't just force companies to avoid a specific market?
Yep. So because the regime is first and foremost voluntary, they don't need to leave. It becomes mandatory if the financial authority, let's say, mandates some sort of regulation, or the health sector. Now, if they need to leave due to some mandated regulation, there's not much we can do as an authority, but we are going by the principle that if our financial authority is putting certain regulation in place, then it should be there for the right purpose. If not, as an authority, we will combat against these local regulation.
Mr. Joshua, I'd like to give you one more minute for final words, since we are almost at the time for the presidential address. So please, could you please have final words?
Yep, so it was a pleasure being here, and I look forward to seeing how the tech, law, AI, regulatory world does evolve. It was a pleasure.
Perfect. Thank you very much, everyone. And now, in 1 minute, we will all join the presidential address for Mr. Enrico Francesconi, our president, for the speech, The Winter, the Summer, and the Summer Dream of AI and Law. Thank you very much.
Okay, good morning, good afternoon, and good evening for everybody in all time zones. It's my pleasure and my honor to present now the president of the International Association of Artificial Intelligence and Law, Enrico Francesconi, who is going to give his presidential address today. Enrico Francesconi is research director at the National Research Council of Italy and policy officer at the European Parliament. He's also contract professor of information retrieval and semantic web technologies at the University of Florence. His main research interests include semantic web technologies for the legal domain, legal knowledge representation, AI techniques for legal document classification, and knowledge extraction. Enrico, it's a great pleasure for me to introduce you to the world, and also to give the floor now for your presidential address. Please, the stage is yours.
Thank you very much, Juliano, for the floor. Let me start sharing my screen. I have to go in full screen mode. Okay, I hope that you can see now my screen. Juliano, can you please confirm?
Yes,
okay.
Yes, perfect.
And can you see the scrolling?
Yes.
Okay, okay. So thank you very much again for your presentation. I'm very glad and honored to give the presidential address at this year edition of ICAIL. First of all, let me say that I'm very pleased to serve as president in this term, to serve the community at this level. And today to give an overview of the long journey of ICAIL conference series from my perspective throughout different seasons of research in AI and law in particular. I'm part of a generation that joined ICAIL in the early 2000s when the pioneers of AI and law have already established the foundation of the discipline. And a new generation of researchers joined ICAIL during a phase of maturity of the so-called web revolution. And in this period, I would like to underline a singularity for the AI and law domain, which is actually the semantic web maturity. There's no doubt, in fact, that keywords like semantic web, smart data, ontologies, linked open data, as well as machine learning and natural language processing are key aspects of the general topic of artificial intelligence and the specific one in artificial intelligence and law. We all know that everything started with the famous article of Lee Levinger of the Minnesota Supreme Court with his article on jury metrics, which underlined a way to approach the law inspired by computational method. But among the pioneers, let me also recall the work done by the National Research Council of Italy in Florence, so the institute where I'm coming from, with a series of international conferences on logica, informatica, and diritto, which were organized throughout the 80s, the first in April 1981, in September 1985, and finally in November 1989. In the same period, the International Association for AI and Law was established to support, develop, and promote the field of AI and law at international level. And here you can see the pictures of all the former presidents of our association. The AI and law pioneers developed their first studies throughout the 80s in the so-called AI winter, which was a period characterized by a substantial disillusion about the expectation of artificial intelligence research and its results. And the main characteristic of the AI, it was a period, let's say, that was characterized by particular characteristics. The fact that in that period we had limited results of a symbolic AI with a toy application, characterized by cost and complexity to represent and keep rules and information, for example, using Prolog. And it was also clear since the beginning that not every type of information is representable in symbolic form. And also the attempt to introduce connectionist models reveal their first limited computational capabilities. For example, related to the perceptron algorithm of Rosenblatt and the XOR problem identified by Minsky and Popert. And so all these facts determined the so-called AI winter, so the crisis in the AI research. But there's no doubt that currently we are facing a hype for AI technologies with a dramatic growth of interest in the research and of AI, in the applications of the AI, which is usually addressed as the fourth industrial revolution. This is also testified within the AI law domain. We can see here the overall registration trend, which this year reached a relevant number, which testifies the good health of the ICAL community. And in fact, ICAL 2021 in Sao Paulo has been a success. It was hard, the decision to go completely online, but the local organizer have taken the risk, refocusing on the opportunities for the online version. And I think that the challenge is one. We had more than 500 participants in the pre-event, around 1,400 registration to the main conference, 89 paper submission, 11 workshops, 1 doctoral consortium, and the new YouTube channel of the association, highly supported by the executive committee for providing new opportunities of dissemination even for the future, not only limited to this very conference. So we are actually at the end of the AI winter, and we can have a look at what happened during these years in the AI law community, and to see what's going on for the current hype. Our first president, Thor McCarthy, since the beginning identified two distinct motivations for this research in AI and law: practical and theoretical. The theoretical motivation aims to gain a better understanding of the process of legal reasoning, legal argumentation, and using computational models and techniques. And the practical motivation aims to build intelligent legal information systems supporting legal practitioners and decision makers and citizens. And since the beginning, Thorne underlined some of the key questions in our domain. So how much of legal reasoning can be reduced to reasoning with rules? And how is it possible to reason with cases at all? Or is it possible to develop a computational theory of legal arguments? In order to respond to this question, Thorne identified a possible solution in the need of a deep conceptual model. And he also identified an obstacle in the so-called knowledge representation problem. That's why in ICAL 1989, he introduced a language for legal discourse. On the other side, Trevor Bench-Capon underlined that intelligent legal information system for most practical application can be built without deep conceptual models. An expert system, as we used to address the system at that time, can be based on formalization of legislation and faithful representation of legal rules. That's why he introduced a key concept, which goes under the keyword isomorphism. And moreover, he tried to identify the possibility to learn the rational underlying decisions given only a set of decided cases. And he wrote an interesting paper in ICAL 1993 in this respect. Now, they seems to be a different position, but to my mind, they represented complementary position, which aimed to address two different and complementary point of view in AI and law research: the top-down approach and the bottom-up approach to AI and law. which approaches that later on has been developed in terms of rule-based or case-based reasoning, or knowledge system or data systems. But these two approaches since the beginning laid the foundation for going out from the AI winter. And in fact, since that time, lots of research has been developed in several domains, like, for example, subdomains of the AI and law, for example, legal reasoning, in terms of developing profiles for non-monotonic reasoning, for rule-based approaches to the feasible reasoning, models for adversarial legal reasoning, and deontic logic. Similarly, other works address the problem of the general theory of argumentation, the description of dialogues between parties, the analysis of rules and precedents, the problem of persuasion and values in legal arguments, argumentation schemes, and arguments and stories. And more recently, the problem of legal reasoning in conjunction with ethics and explainable AI has been underlined. In the early stage, we had the famous Cato system, which aimed to address the problem of case-based reasoning and factors. And later on, other works are related to deontic logic, responsible AI, and evidential reasoning have been developed. Finally, lots of work have been carried out in data systems to introducing connectionist models applied to the legal domain, to legal information retrieval and discovery, for argument extraction, for legal predictions, legal text summarization, legal network analysis, and quantitative reasoning. One of the first attempt to bridge the gap between case-based and rule-based reasoning was carried out by Kevin Ashley and Wiener Riesland in the IPO system for introducing reasoning with cases and hypotheticals, and in particular in the system Cabaret, including rules and cases to solve case-based reasoning problems. And a similar problem was underlined by Carl Branting, which underlined the need for building explanation from rules and structure cases. In ICAL 2019, our former president, Bart Verhey, underlined and identified a target in 2025 as the date in which we could bridge the gap between knowledge system and data system in AI. He addressed the problem in terms of AI as law, meaning the process for building hybrid systems connecting knowledge representation and reasoning techniques with machine learning. Now, the lesson learned from the first AI debate is that we have achieved lots of theoretical achievement in terms of both symbolic models and sub-symbolic or connectionist models, but still a limited number of large-scale applications. So we have now, I think, to wonder why this actually happened. From my point of view, this happened for the strict link that there is between, we can establish between AI and knowledge, and which is also at the basis of the first period of the AI winter. According to Alan Rich of the University of Texas and Kevin Knight of the University of South California, intelligence requires knowledge. And the AI winter was mainly due to the insufficient amount of knowledge. Now, managing knowledge poses some problems. It is voluminous, it is hard to characterize accurately, it is constantly changing, and it differs from data because it needs a semantic organization. But in the early 90s, AI meets the web, and this changes everything. In fact, this poses actually the ground for going out from the AI winter, because the web can be considered as a source of knowledge for AI, for the availability of a huge quantity of information in digital format for the development of AI systems. And also the web is a stimulus for AI development, because internet and the web in particular need advanced AI applications for managing data. So the evolution of the AI has followed the web, the evolution of the web. We all know that currently we are in the so-called Web 3.0, starting from derived from the Web 1.0, so the static web, the Web 2.0, also known as social web, and finally, currently we are in the maturity phase of the so-called semantic web or web of data, or sometimes also addressed as the Internet of Things. The semantic web has specific objectives, so the technological and semantic interoperability between information systems, so to give the possibility of advanced information services. A great boost to the development of the semantic web in large scale was given by the famous article of Tim Berners-Lee with introducing the famous 5-star rating schemes for linked open data. And from that time, in 2006, we have had a dramatic growth of the linked open data cloud. This is a picture from 2007, from 2008, 9, 10, 2014, and from that time, the phenomenon has exploded. So going back to the Rich and Knight motto, intelligence requires knowledge, we can say that knowledge is nothing but a combination of data and semantics. But knowledge is actually on the web, and in particular, we can say that knowledge is on the semantic web. And knowledge in the semantic web is also important for AI in law, because it provides semantics for a top-down approach to AI in law, in terms of legal knowledge representation, reasoning and argumentation, planning and explainability. And also it provides a large amount of data, or smart data in particular, for bottom-up approach to AI in law, in terms of machine or deep learning and natural language processing for rule-based or case-based systems, argument mining, legal information discovery and retrieval. So we are clearly in the summer of AI and law, as we have seen before, with lots of opportunities for developing interesting and effective systems for of AI for the law domain. And we are, I think, in the summer because actually the semantic web is now mature and it represents the basic infrastructure for AI, because it provides languages for knowledge representation, and it provides also smart data for intelligent systems. Now, from the lesson learned in the AI and law debate, we have seen the need for knowledge models, for languages for knowledge representation, the need for describing rules and having them the possibility to activate such rules, the possibility of developing logic systems and algorithms for legal reasoning, and having the possibility to exploit data and smart data. And this is actually what the semantic web does. So the semantic web is an infrastructure also for AI in law, in the law domain. It provides languages, so standards and languages for legal knowledge representation, and it provides smart data for legal autonomous agents to mimic intelligent behavior. Mm-hmm. So the role of the semantic web for AI in law is rather clear. It provides standards, it provides and languages, it provides linked open data, so smart data, and it provides a stimulus for developing machine learning and deep learning facilities for transforming the law into code. And having the law as code, we have the possibility to exploit smart data for developing AI and law application in large scale. And the semantic web in the AI and law domain has already been developed quite a lot. And we have interesting solutions developed by the University of Bologna, from the University of Amsterdam, and also Kevin Ashley in a specific article identified the importance of ontologies for analogical legal argument. And this is also the scenario of my research, which is actually addressed to the representation of legal rules has described according to two different levels of abstraction. In terms of provisions, has a set of signs organizing words and sentences for creating normative statements, and norms for in terms of the meaning or application of such normative statements. So we can say that provisions are textual objects that can be used for applications like information retrieval or legal drafting, and norms are social objects. And so we can use such representations in terms of, let's say, legal compliance or other such kind of applications. So in my research, I developed a model which is called provision model using semantic web standards. And this model has been used for legal drafting activities in terms of model-driven legislative drafting and regulative impact analysis. We have used such model for semantic annotation of provisions by machine learning and natural language processing, so basically for extracting knowledge from legal text, to develop legal information retrieval services, implementing, for example, Opheldian reasoning within a description logic framework. And more recently, the description of norms have been used for legal compliance checking, still in a description logic framework, a decidable framework. Now, one of the research questions I think that has to be underlined is to identify sufficient conditions for implementing legal reasoning within the description logic framework. And in particular, for example, using also extension to this, to the classical description logic in terms of DL rules or DL safe rules. We can address several problems within this framework: standard or temporal deontic logic, non-monotonical defeasible reasoning, argumentation schemes, and legal reasoning in general. The motivation is that we can use available reasoners within a decidable computational framework. And the key hypothesis in my view is that the key factor is the quality of legal knowledge modeling. And some examples exist in literature, some examples coming from the University of Amsterdam, another interesting work from Guido and Serena about using linked open data for legal compliance. And I also developed my research within this framework, for example, for modeling of Opheldian reasoning within a description logic framework, introducing specific relations in terms of implicit and explicit knowledge, of implicit and explicit provisions. And more recently, I developed a model for legal compliance checking within the description logic scenario. So the regulated scenario can be represented as a domain ontology, and the deontic rules can be expressed as property restrictions. And this model proves the ability to cope with some profiles of norm defeasibility. So I think that within this framework, we have several opportunities to develop AI systems in large scale. And in order to develop such system, we have to exploit the dramatic growth of data that will be available from here until 2025. And this is a picture of the data growth prediction. And the opportunities for AI in the legal semantic web or in the legal domain in general is sizing the opportunities of the next data wave, combining top-down and bottom-up approaches, so using semantic web standards and inference tools, which are already available for legal reasoning, machine and deep learning for legal knowledge extraction, data for system evaluation compared to existing baseline, and finally, exploiting interoperability between information systems. Also, from the point of view of the political point of view, recently the European Commission published a white paper on artificial intelligence, which aimed to promote the creation of excellence and testing centers that can combine European, national, and private investments. The aim is to promote a new public-private partnership in AI, data, and robotics, and promoting also the adoption of AI by the public sector. And finally, creating an ecosystem of trust, so a regulatory framework for AI. So I would say that the AI research is highly supported by the European institutions. And this is actually what the European Commission is working on. So to create, in particular, the European Union Open Data Cloud centered on EU law. And we can see here the picture of the map, let's say, of the data managed by the seller repository of linked open data managed by the Publications Office of the European Union. And recently, the European Union Open Data Portal has been released. This is the official portal for European data. And by 2021, also the European Parliament will publish the European Parliament Open Data Portal, reachable at this address. And so we can see that there is a great interest in these topics, in particular from the legal tech companies and startups. And we can see here from this picture from the Bill Anderson web page how rapidly the legal tech is expanding in the legal matters. So we have companies and startups in the topics of smart contracts, e-discovery, security and compliance, transaction management, document analysis, case management, legal research, document automation. And actually, this is what also Richard Susskind told us, has invited speaker at ICAIL 2017. Actually, according to Richard Susskind, we have to catch the momentum, because the legal institutions and lawyers will change more radically in less than 2 decades than they have over the past 2 centuries. And the same concept was expressed by Katie Atkinson in her presidential address of ICAIL 2017. She said that plenty of law firms are interested in hearing about what our research can offer. So now we have seen how many opportunities we have in this domain, and let's take the liberty of dreaming a bit in the summer of AI. So what's going on in the next? I think that the next generation of AI system will be linked to the evolution of the web, and in particular in what in the literature is addressed as Web 4.0, or also called symbiotic web, where humans and machines can interact one to another, and machine will interact as well. So nowadays we have already personal software agents, but in the next future we will have more advanced system for booking flights, for making the best economic investment according to the user financial risk profile. We will have autonomous or self-driving cars and so on. But in particular, in the legal domain, as well as in the Web 3.0, we have the law understandable and processable by machines. In the Web 4.0, we can have intelligence agents for legal data mining and e-discovery, and in particular, the creation of a system to act as digital judges with knowledge of personal profiles, specific cases and laws, taking decision on legal dispute. Now the question is, to what extent an algorithm will be able to substitute or support the human legal reasoning? In order to respond to this question, we can make a reference to the so-called paradox of Hans Moravec of the Carnegie Mellon University. He theorized the time of human equivalence. At that time, T0, human intelligence and artificial intelligence will be no more distinguishable. So if it exists at that time, the research in AI will be reduced to an empty set. So will it be the end of AI research? In order to respond to this question, we have to respond to other more specific questions. Does a human judge argue by deductive categories only? Can we say that the roles of emotion, are there any roles in the emotions in taking decisions? Will a judge, a digital judge, emotionally neutral, be fairer than a human judge? And finally, the question of the question, I would say, is the human brain algorithmic? Well, to answer to this question, we can refer to a famous theorem, the Girdle theorem of incompleteness. According to the Girdle theorem, a coherent or non-contradictory system of rules is necessarily incomplete. That is, that there are truths that cannot be proved with the axioms of the system itself. Now, truth that cannot be proved means that they cannot be derived automatically. Now we can say that a computer is a set of circuits that reproduces logical, coherent, and consistent rules of thought. So basically, computer is an incomplete system. But humans seems to act differently. Humans guess as true claims not derived automatically. They guess the axioms. So we can say that human brain seems to reconcile consistency and completeness of a system of rules. So a question is human brain an exception to the Gödel theorem? According to Roger Penrose, this is the case. Human brain is not algorithmic. Roger Penrose is also Nobel Prize this year for physics and from the Oxford University. So this is a famous motto of Roger Penrose: human brain is not algorithmic. We can say that human brain is not a Turing machine. So in order to get closer to human intelligence, will AI have to manage emotions and intuitions? Well, this is actually what Joshua Benjo in ICAL 2019 told us as invited speaker. He said that lots of knowledge is intuitive. So in order to deal with let's say, intuition and emotions, we actually have to deal, according to the literature, to the Web 5.0 or emotional web, where human and machines interaction will comprise emotions. So emotions and intuitions will be processable data. So we it be a matter for quantum computing? Well, we actually don't know yet if this will be the case. But anyway, we can say that at that time in the Web 5.0, where emotions will be processable data, how will you be able to persuade a digital judge? So with this question, I thank you very much for your attention, and I look forward for your questions.
Thank you very much, Enrico, for your very inspiring presentation. I'm checking here whether there are questions from the audience. Okay, there is a question by Floris Bex. Hi, Floris. Do you have an idea on how the European Union wants to cater to both AI innovations and AI regulation, given the draft AI regulations?
The European Commission, as far as I know, especially with the white papers on artificial intelligence, is promoting both of the issues that have been raised. So both the technical aspect and the regulatory aspect. In particular, the role of the institution is to promote the cooperation between private and public initiatives. And I think that especially at the level of a European institution, the keyword AI seems to open many doors, and there is lots of interest in this respect. So I think that it's really time to catch the opportunities from both the technical point of view and the legal framework point of view. And I think that we can obtain, let's say, we can have an audience in this respect.
Okay, we have a question by Trevor now. The availability of so much data is a mixed blessing. We understand that the law, better by the thorough analysis of a few carefully selected and reported significant leading cases, as we did in good old-fashioned AI law, that from a very large number of routine cases where the decisions may not tell us anything and the quality of decisions may be variable, more is not necessarily better. So it's actually a comment, if you would like to comment on.
Yeah, I totally agree with Trevor. That's why I think that the combination of data and semantics is a way to filter at best the relevant cases, for example, that can be prototypical for solving a specific case or to, let's say, describe a specific state of affair. I totally agree that having lots of data is not a solution, but having data allows you to train machines in a better way, to implement tools that can be more selective, and we can introduce, let's say, knowledge in our systems, which is actually seems to be something that is missing, or let's say not is missing, is needed for developing AI systems, and in particular AI and law systems.
There is a question now by Bart Verheij. Thanks for a very interesting talk, he first says. Then the semantic web is especially good at recording and managing the law as it is. What would you say about the dynamical development of law, both in the general rule of law and its application in a concrete case? I would add also the dynamics of legal change and also the interpretation of law, which is based on changing and adaptation of the content of law.
Yeah, I don't know, maybe I'm biased, but I would say that this is actually what you can do with semantic web technologies. For example, the same piece of legislation can be interpreted in different ways by different actors. And you can, let's say, implement a specific ontology that allows you to provide a view on a specific piece of legislation, or to use another view given by another player, which might be more authoritative than the other. Similarly, the dynamic nature of the law can be, it's actually represented using semantic web standards. There are already lots of let's say systems that allows you to create, for example, the consolidated version of a piece of legislation, which can change over time. So as I said, maybe I'm biased because I'm working in this field, but in my view, you have an effective framework. You have, let's say, the language, you have the standards, you have the possibility to create your knowledge models that allows you to provide specific views in terms of interpretation at a specific point in time of the evolution of the law. So this is, I think, this is an important aspect to consider.
Oh, Mikhail Araksevich is thanking you for this great address, and he's questioning you. He's curious about your opinion concerning automating creative processes, which is essential to the work of lawyers.
I don't know, Michal, maybe you mean creation of, for example, automatic document drafting or counter creation and so on, I think. Well, as I said, you have to consider all this system as a support for the work of the lawyers, but they can streamline a bit, very much their work, especially obviously in repetitive tasks. For example, at the beginning of my career, I worked in the field of legal drafting, legal drafting, yes. And we provided some tools for the creation of a model-driven legislative drafting. So having, let's say, a support for the automatic creation of documents using a specific semantic model. This can be beneficial for the clarity of the law, for let's say improving the accessibility of the law, and for let's say making a so-called better legislation, which is, by the way, one of the main let's say action of the European Commission that they are promoting. They have been promoting for quite a long time.
Thank you. Jaromir Zavelka is following Trevor's question, and he comments that he remembers that at ICAIU 2013 in Rome, the lack of AI and law data sets was identified as one of the biggest issues for our community. How do you think this has changed? Is it still a priority?
I think it's a priority, absolutely, because it allows you to, for example, to train, let's say, connectionist models in an effective way. Let's say the movement that can overcome this problem is given by actually what we have called, or we have addressed in the presentation as the linked open data approach. because you don't need to have a specific repository of this content, but this content is distributed over the web according to specific standards and specific APIs, so application program interface. This allows you to have a more flexible and let's say scalable solution for let's say filling the gap between knowledge systems and data systems, as my friend Bart used to call the problem.
Enrico, I also have a question. As you have addressed, this is the key aspect of our summer, as you have mentioned. The key aspect is the combination of knowledge systems with data systems. And you mentioned that we are in the first steps in this direction. When do you believe, what's your guess for the time that we are going to reach maturity in this research challenge, considering that you are considering also your dreams today? So what are your dreams regarding this particular desideratum for the research on AI and law?
Yeah, for me, as much as we follow the combination of a top-down and bottom-up approach, the more we address this combined approach, the better will be to reach this coordination between knowledge system and data system in an effective way. So I think that this is actually two different perspectives or two different sides of the same medal, the same coin. At the end, you will reach the same point of contact from top or from the bottom. You need knowledge models for reasoning, and you need data for implementing systems. So at the end, these are the two combined approach that, let's say, will be beneficial for creating systems and in particular AI and law systems, which is effective for large scale applications.
Jack Conrad is thanking you for your talk, and he mentions that you ended your talk with a look to the future and properties of Web 5.0 that this web might embrace, including a point where machines and as well as humans processes emotions. How essential do you think such a property is for AI systems in order to achieve further progress, that they possess such human-like characteristics to be effective? So how essential it would be?
Well, I don't know. I can say that if you go in a trial, I don't think that you can consider that the decision of the judge is completely, let's say, deterministic or follow, let's say, deductive path. So sometimes actually emotions or, let's say, more, let's say, more fine-grained elements affect the decision of a judge. So if you want to mimic at the end completely this attitude, you have to consider also this aspect. I know that now it seems like a dream, as I said before. It's more a matter of science fiction rather than research. But actually, already there are services on the web that works according to preferences of the users. They want to let's say, exploit their sentiments, the famous sentiment analysis. And it's not completely out of the research framework to think about this aspect, because if you are able to let's say govern this phenomenon, you will be able to create really systems that mimic the human brain. But as I said in my presentation, probably there is a structural limit, definitely there is the structural limit given by the Girdle theorem, which says something very plain and I would say trivial, but very simple, that the fact that humans have let's say aspects that are hardly modeled by machines, which is subject to the Gödel theorem, while humans seems not. So this is also, I would say, a sort of philosophical aspect to consider, but this doesn't prevent us to follow this dream and to go through this kind of research, because it might open unexpected doors.
Great. Vern Walker is congratulating you for your excellent presentation. And he says that he would appreciate your thoughts on whether practical applied theories of legal reasoning are falling behind the availability of technical tools.
Sorry, Juliano, could you repeat the?
Yes, he's asking whether, for your thoughts on whether practical applied theories of legal reasoning are falling behind on the availability of technical tools. So if there are no enough technical tools for applied theories of legal reasoning.
No, I would say that this is not probably essential, because you can follow this line of research even from a pure theoretical point of view. It is also true that at some point, if you are a researcher in AI, you want to have to see something applied, I think. It's important from my point of view to identify, as I said in my presentation, the framework. So let's say the limit of specific profiles of legal reasoning that can be implemented of using existing reasoners, which are, for example, available for description logic or for other profiles of logic. But I don't think that the lack of tools prevent us to go through this line of research.
Trevor is now with another comment. He's saying we need analyzed data, example, the ascription of factor to cases as in Cato, rather than raw data. We also need benchmark data sets to allow comparisons.
Absolutely. I totally agree with Trevor. We don't need raw data, we need smart data. It's exactly the point of my presentation. You need to extract knowledge from raw data. You need to have data that are semantically described so that, let's say, intelligent systems can process those data and, let's say, implementing profiles of legal reasoning or, let's say, deductions that you can obtain if you have this kind of data semantically qualified. And this is also a contribution to the explainability of AI, which is sometimes not true using raw data or pure subsymbolic systems. So I agree on what Trevor said.
And Enrico, being carried on by your dream on an emotional web. And we know that our works on AI and law and the models of legal reasoning that are discussed and explored are mostly based on legal theories whose tradition is analytic in its essentially. And now that you want to open room for discussions on emotion, do you think that we should be open and to visit again within the community discussions on legal theories that oppose the analytical trend with virtual theories, for instance, that open room from emotions in the legal analysis of particular judgments?
Yeah, for me, this can be the case. Obviously, it's for now. I think that we know our limits, but nothing prevents us to think different, as someone else has said, and maybe to go in a direction that seems to be full for someone, but at the end, it's a way to try to approach the reality and to reproduce the reality in a proper and effective way. So I agree. I agree on that. I agree on what has been said.
Okay, Enrico, we have run out of time now. It was really a great presentation and very interesting discussion. Thank you very much for the insights and for the inspiration to the community with your dreams. Thank you very much, Enrico.
Thank you very much, Juliano. Thanks to all of you for your attention.
Okay, thank you.
Thanks.